Good morning, and to those of you who are on the other side of the world, good evening. I'm delighted, I'm Yvonne Baatz, and I'm delighted to welcome you to this webinar entitled Two Perspectives on Ship Finance, English Jurisdiction Clauses and Innovation. It's organised by the Centre for Commercial Law Studies at Queen Mary, University of London, where we're celebrating our 40th anniversary. And I'm very pleased that Ian Gaunt has agreed to chair this webinar. Ian, of course, will be well known to very many of you as an arbitrator and past president of the London Maritime Arbitrators Association. He has extensive experience of shipbuilding contracts and disputes and is co-author of the 5th edition of the Law of Shipbuilding Contracts, which is hot off the press, published by Informer in May this year. Ian, over to you.
Thank you very much, Yvonne, and thank you for that excellent plug for my book. It's a pleasure to welcome everybody to the seminar today. This is a very timely subject, and it's excellent that we've been able to put this on in the 40th anniversary year of the Centre for Commercial Studies. We have a very large audience today, and I would like to just mention 3 housekeeping points before we start. The first is that please can you make sure that you apply the mute function throughout the seminar. You'll have an opportunity to ask questions using the chat function, which most of you will be familiar with by now on Zoom, and we will see those questions and we'll be able to pose those at the end of the presentations by the speakers. The second also is if you can switch off the video mode so that we save bandwidth and so that it doesn't interfere with the presentations on screen. And then the third I've already mentioned, that is if you want to ask questions, please can you do that by using the chat function. But it's a pleasure, first of all, to introduce our first speaker, who is well known to most of you. Professor Yvonne Baatz is a professor at the Centre for Commercial Law Studies at Queen Mary, University of London. She's the author and editor of Maritime Law, the 5th edition of which will be published this summer, so I can return the compliment and give you a plug for your book as well. And she has, as you know, published very widely on subjects related to the conflict of laws, carriage of goods, charterparties and marine insurance. And she's going to speak to us for approximately 30 minutes about English jurisdiction clauses in ship finance and security. And after Yvonne's presentation, we'll have about 10 minutes for questions on her presentation, and then we'll move on to Miriam, Goldby and Panagiotis, Vavougyios. So without further ado, Yvonne, can I hand over to you to give your presentation? Thank you.
Thank you, Ian. I'm just going to turn off my video because that will give us better connectivity, I hope, with my PowerPoint presentation. I hope everybody can now see the PowerPoint presentation's full screen. And as Ian said, I'm going to look at English jurisdiction clauses in ship finance and security. It's very common in ship finance contracts, such as bank loan agreements, to provide for asymmetric jurisdiction clauses. And that's what I want to focus on in the first part of this talk today. Provide that if the borrower brings proceedings, it can only do so in England, whereas the bank may bring proceedings against the borrower in any competent jurisdiction. And I want to look at some of the recent case law, particularly the first instance judgments in Commerce Bank and Etihad. Etihad is under appeal, and I'm going to say something about those 2 cases. What I also want to consider in the second part of this talk is security for the loan. When a bank enters into a loan agreement for the purchase of a ship, it will take security for that loan, which may include a mortgage of the ship, assignment of the hull and machinery insurance policy on the ship, and loss payee clause in that policy. It may have mortgagees interest insurance, assignment of the earnings of the ship, and there may be a guarantee from the director of the ship owner or the managers of the ship. And what I want to consider in the second part is jurisdiction clauses, particularly in relation to the assignment of the hull and machinery insurance policy and the decision of the Supreme Court in Aspen Underwriting and Credit Europe Bank NV. I seem to have jumped too many here. No, let's just go back to, what I want to do is look at 4 schemes of rules which could be applicable to a jurisdiction clause. The first, the Recast Regulation, which applies to legal proceedings instituted on or after the 10th of January 2015. Secondly, the 2007-2005 Hague Convention on Choice of Court Agreements. And lastly, fourthly, the common law rules. I will say something about each of those rules in turn and what we may have in the future. So if I start with the Recast Regulation, the Recast Regulation continues to apply to the United Kingdom at the moment, even though we have withdrawn from the European Union. We've kept period until 11 p.m. on the 31st of December 2020, but it's very unlikely that it will continue to apply thereafter if, as our government says, they're not going to extend the transition period. That's their current position. Article 25 is core to the Recast Regulation and provides that if a court is chosen, if a member, the courts of a member state are chosen, that court shall have jurisdiction. And in addition, we've got important lease pendants provisions in the Recast Regulation, which in Article 29 provides that if we've got proceedings going on into courts of 2 different member states, then any court other than the court first seized shall stay its proceedings. But that is subject to a very important exception in Article 31, because Article 31 provides that if there is an agreement which confers exclusive jurisdiction, then the court which is chosen can proceed with its the matter, and the court first seized but not chosen must stay its proceedings in favour of the court chosen. So the first recent first instance case I wanted to consider was Commerzbank, which has entered into a loan agreement for a number of ships, and Liquimar had guaranteed 2 of the loans. I just wanted to read to you the relevant bit of the asymmetric jurisdiction agreement, just to show you the sort of provision you might expect to find. So if I go to 16.2, it says, for the exclusive benefit of the lender, the guarantor irrevocably agrees that the courts of England shall have jurisdiction to settle any disputes which may arise out of or in connection with this guarantee. And then 16.3 provides nothing contained in this clause shall limit the right of the lender to commence any proceedings against the guarantor in any other court of competent jurisdiction. In Liquimar, the Liquimar commenced proceedings in Greece, and the bank then commenced proceedings in England. And the question, English court could had to stay the proceedings in England, or could, sorry, I'm having a bit of difficulty with the slides here. so the question here is whether under Article 31.2, the asymmetric jurisdiction agreement is an exclusive agreement, and in that case, Mr. Justice Cranston held that it was, and therefore the English court considered the 2005 Hague Convention and said that it was of no assistance in the interpretation of Article 31.2, which I will come back to. He further held that as the court chosen, if the English court decides that it has jurisdiction, it could proceed with the case irrespective of how far advanced the Greek proceedings were, and did not have to stay its proceedings until the Greek court had decided whether it had jurisdiction. And that question has also subsequently been considered in Dexia Crediop and the Generali Italia case, which has also agreed with the position in Liquimar. The second case is Etihad, and in Etihad, Etihad entered into a facility agreement with Air Berlin, which was in significant financial difficulties. And under the facility agreement, it agreed to advance €350 million, contained an asymmetric jurisdiction clause, and there were similar clauses in other agreements reached at the same time. But Etihad also gave a comfort letter to Air Berlin, which did not contain a jurisdiction clause. And the insolvency administrator of Air Berlin then commenced proceedings in Germany, and Etihad commenced proceedings in England. The essential question was there a jurisdiction clause in the comfort letter? And it was held that there was, and that jurisdiction clause, again, the asymmetric jurisdiction clause, fell within Article 31.2 of the Recast Regulation as an exclusive jurisdiction clause. So again, Mr. Justice Jacob holds that Article 31.2 does apply to asymmetric clauses. He also considered the 2005 Hague Convention, but held that it did not assist in the interpretation of Article 31.2 of the Recast Regulation. I will come back to that. And he considered that it wasn't necessary to refer the issue on Article 31.2 to the Court of Justice of the European Union. Mr. Justice Jacob cited Louise Merritt in her article, and I've quoted from that. I think the most helpful bit, I'm not going to read it all out here, is that she says it really doesn't matter what the position as far as the bank is concerned. As far as the borrower is concerned, it is subject to an agreement for exclusive jurisdiction. I have to say the Cambridge academics Richard Fentiman and Louise Merritt have written extensively on asymmetric jurisdiction clauses, and their position, accepted in those two first instance judgments, is that asymmetric jurisdiction clauses are exclusive jurisdiction clauses and therefore binding under Article 31.2. Etihad is under appeal, and therefore we now have to wait to see what the position on that appeal is. The second set of rules I wanted to consider briefly is the 2007 Lugano Convention. That too is currently applicable in the United Kingdom during the transition period. But on April the 8th this year, the United Kingdom deposited its application to accede to the 2007 Lugano Convention in its own right. And if that were acceptable to the European Union and Denmark, then that would apply after the TM on the 31st of December 2020. Iceland, Norway and Switzerland have already stated their support for the United Kingdom acceding to that convention, but we have to wait to see what Denmark and the European Union decide. And it will depend now on whether Boris Johnson and his oomph, which he hopes to inject into the negotiations with the European Union, can succeed on establishing the 2007 Lugano Convention. One of the problems with the 2007 Lugano Convention is that it doesn't contain an equivalent of Article 31(2) of the Recast Regulation, and therefore we're still stuck with the decision of the European Court of Justice in Eric Gasser and Misat, and that has just been considered in a recent decision of Mr. Justice Waxman in Mastermelt, listed at the bottom of this slide. In that case, he decides that the decision of Gasser and Misat is still applicable to the 2000 decided on a former version of the Recast Regulation, and you cannot, because the Recast Regulation has Article 31(2), say that that also should apply retrospectively to the 2007 Lugano Convention. So the 2007 Lugano Convention, not as good for us as the Recast Regulation, but better than nothing. The third situation that I wanted to consider is the 2005 Hague Convention on Choice of Court Agreements. This is currently in force in 31 states. It was acceded to by the European Union. It continues to apply to the United Kingdom at the moment during the transition period. And the United Kingdom has made clear its intention to accede to the convention in its own right. So only 31 of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which has been ratified by about 160 states. What is the position under the 2005 Hague Convention in relation to jurisdiction agreements, and particularly asymmetric jurisdiction agreements? A court which is chosen under an exclusive court jurisdiction agreement shall have jurisdiction under Article 5, and Article 5 defines an exclusive jurisdiction agreement. No other court can take jurisdiction under Article 6, and any resulting judgment must be enforced by the other contracting states. Let's just have a look at the scope of the 2005 Hague Convention. It does exclude certain maritime matters, such as the carriage of goods, but it does apply to other maritime contracts, such as ship finance contracts, ship mortgages and liens, shipbuilding contracts, ship sale and purchase contracts, probably time charter parties, because they're probably not carriage of goods, and contracts of marine insurance and reinsurance. Here, Article 3 on exclusive jurisdiction agreements. It's also worth just saying here that states may extend the application of the convention to non-exclusive jurisdiction clauses by making a declaration, but none of the contracting states have so far done that. In the explanatory report to the 2005 Hague Convention, it was stated that an asymmetric choice of court agreement is not regarded as exclusive. And Mr. Justice Cranston in Liquimar considers the position. I've quoted here what he's had to say in that judgment. It's also the Hague Convention considered by Mr. Justice Jacobs. But if I move straight to paragraph 217, Mr. Justice Jacobs says, like Mr. Justice Cranston in Liquimar and Louise Merritt in her article article which I've referred to, I consider there are good arguments that the rules in the Hague Convention do apply to, I'm just going to try, yes, that's much better. Sorry, I had all sorts of pictures of people on top of my slides, but I can see much better now. He considers there are good arguments that the rules in the Hague Convention are engaged by an asymmetric clause. In other words, he thinks that the Hague Convention would apply to an asymmetric clause, but in any event, he holds that that doesn't assist him in interpreting the recast regulation, and that he thinks probably actually the recast regulation has an impact on how you should interpret the 2005 Hague Convention. So just to summarize, let me just deal with the common law rules. Common law, and these rules may become much more important if we don't manage to secure our, once the transition period has expired, because if we had a no-deal Brexit, then we'd go back to our common law rules. Under the common law rules, asymmetric jurisdiction agreements are valid and enforceable. I've also put on the slides remedies for breach of an English jurisdiction agreement, anti-suit injunctions, damages for breach of contract, and indemnity costs, and I've referred you to the recent case law. I'm going to skip over those here, though. You've got the recent case law in view of the time position. So just to conclude, on asymmetric jurisdiction agreements, they're exclusive as far as the borrower is concerned under the recast regulation and by analogy, the 2007 Lugano. The position under the 2005 Hague Convention is not clear, but there is support in Liquimar and Etihad for saying that asymmetric jurisdiction agreements are exclusive as far as the borrower is concerned. And at common law, asymmetric jurisdiction agreements are exclusive as far as the borrower is concerned. So what I wanted to turn to now, the second part of this presentation, is to look at security for the loan agreement. We've already looked at the various different types of security that a bank or lender might take, but what I want to focus on specifically is assignment of the hull and machinery policy. And this was considered in the Supreme Court decision in Aspen Underwriting and Credit Europe Bank. In that case, Aspen Underwriting Ltd and others insured the Atlantic Confidence, owned by Carriage Shipping, a Maltese company, under a hull and machinery insurance policy with a value of $22 million US. The policy had an exclusive English jurisdiction clause, not asymmetric, just an ordinary exclusive English jurisdiction clause. The bank, domiciled in the Netherlands, funded refinancing of 2 vessels, including the Atlantic Confidence, and the bank took a mortgage over the vessel and assignment of the policy, which identified the bank as mortgagee, assignee, and loss payee. On the 3rd of April 2013, the Atlantic Confidence sank off the coast of Oman, and 2 days later, the bank authorised payments in a letter of authorisation from the bank. The insurers then entered into a settlement agreement in August that year with the owners and managers of the vessel to pay $22 million US to Willis. The settlement agreement also provided for English law and an exclusive English jurisdiction agreement. So one might have hoped that that was the end of the matter, but 3 years later, the Admiralty Court decided that the owners and managers had procured the scuttling of Atlantic confidence, and therefore due to the willful misconduct of the owners. The insurers commenced proceedings in London against the owners, the managers, and the bank, trying to recover the sums paid under the settlement agreement. And as against the bank, they alleged that the bank had made misrepresentations that they were entitled to receive the insurance proceeds when in fact there was not an insured loss, and that in reliance on those representations, the insurers had entered into a settlement agreement. The bank challenged the jurisdiction of the London court, and they argued that the matter was a matter relating to insurance, and that therefore they were entitled to rely on Article 14 of the Recast Regulation, which provides that an insurer may only bring proceedings where the defendant is the policyholder, the insured, or a beneficiary. The insurers argued that the bank was bound by the English court jurisdiction clause in the insurance policy. By the time we get to the Supreme Court, they've given up arguing that the bank are a party to the settlement agreement. It was held at first instance by Mr. Justice Tier and also the Court of Appeal that the bank were not party to the settlement agreement. And alternatively, the insurers argue that pursuant to Article 7.2 of the Recast Regulation, on matters relating to tort, the bank would be subject to the jurisdiction of the English court because the harmful event had occurred in England. The Supreme Court held that the bank was not a party to the jurisdiction clause contained in the insurance policy, and nor are they under the settlement agreement. They further held that the insurance claims against the bank were matters relating to insurance, that the bank, as the named loss payee, was a beneficiary of the policy and as such was entitled to rely on Section 3, which affords protection, and therefore the bank could rely on Article 14, which meant that the insurer could only sue where the bank was domiciled, i.e. in the Netherlands. Because they reached that conclusion, the question as to whether the insurer's claims for restitution were matters relating to tort, delict or quasi-delict under Article 7.2 of the regulation were irrelevant, and the Supreme Court therefore didn't deal with that issue. As a result, the English court did not have jurisdiction, and the only place where the insurers could sue the bank was in the Netherlands, where it was domiciled. Lord Hodge, delivering the judgment of the Supreme Court, commented on the jurisdiction agreement. Because the bank was not a party to the insurance policy, but rather a beneficiary, he says at paragraph 25, to determine whether the bank can be seen in EU law as the successor of the owners and managers who are subject to the jurisdiction clause. The bank's entitlement to receive the proceeds of the policy in the event that there was an insured casualty rests on its status as an equitable assignee. It's trite law that an assignment transfers rights under a contract, but absent the consent of the party to whom contractual obligations are owed, cannot transfer those obligations. And if I jump down to the bottom of that quote, this concept, which has often been described as conditional benefit, is to the effect that an assignee cannot assert its claim under a contract in a way which is inconsistent with the terms of the contract. And Lord Hodge refers to the decision of Lord Justice Hobhouse in the J. Bowler and the subsequent Court of Appeal decision in the Yusuf Chetnioglu. And he says that, he quotes the Lord Justice Hobhouse decision, the insurance company in that case is not entitled to assert its claim. The insurance company there was the subrogated insurer, is not entitled to assert its claim inconsistently with the terms of the contract. One of the terms of the contract is that in the event of dispute, the claim must be referred to arbitration, similar in relation to a jurisdiction clause. The insurance company is not entitled to enforce its right without also recognizing the obligation to arbitrate. The problem, however, in our case here, the Aspen Underwriting case, is that the bank did not commence legal proceedings to enforce its claim. Indeed, it had been able to obtain payment under the insurance policy without commencing any proceedings whatsoever. And on that basis, the Supreme Court held that the bank did not even assert its claim, let alone commence proceedings, and that therefore there was no inconsistency between the bank's actions and the exclusive jurisdiction clause. Therefore, the bank was not bound by an agreement as to jurisdiction under the recast regulation. So just to summarize there, in relation to the assignment, if the bank had sued on the insurance policy to take the benefit of the insurance policy, clearly they would be bound by the sue. In this case, they were sued by the insurers trying to get the insurance proceeds back. And in that event, the Supreme Court held that the bank is not bound by the exclusive English jurisdiction agreement. The decision is also important in relation to matters relating to insurance, but I haven't got time to go into that today. And there are a number of articles written on that. I found the Herbert Smith website very helpful in relation to a summary of those provisions. I just wanted to make some general comments on Aspen. The first is, the result of the decision is that the bank has had the benefit of the insurance policy, but is not bound by the exclusive English jurisdiction clause, as it did not sue. So in other words, it's taken the benefit, but the Supreme Court decision is that the jurisdiction clause only bites if there is litigation. And the consequence on these particular facts for these parties is that the litigation is fragmented. The insurers must sue the owners and managers in England, but must sue the bank in the Netherlands, with all the resulting increase in costs and risk of inconsistent judgments in both England and the Netherlands. My third comment is that in future, the insurer should consider whether the bank should be party to the settlement agreement. It was held here that they were not a party, and Lord Justice for the Court of Appeal states that there would have been much good sense in the proposition that the bank ought to have been a party to the settlement agreement. But the question, of course, was whether it was a party, and it was held that it was not. I won't quote his subsequent comments, but he makes further comments to the same effect. The decision in Aspen is consistent with the approach of the Court of Justice of the European Union, particularly in a recent decision, AAS Bolter and UAP Griffiths AG, where for a large risk was held not bound by a jurisdiction clause for the courts of Latvia, even though that jurisdiction clause fell within Articles 15.5 and 16.5 of the Recast Regulation. The third party there was a named beneficiary of the liability insurance contract, but not a party to it. The decision in Aspen is significant for equitable assignment in general, as well as for assignment of an insurance policy, loss payee clauses and subrogation. And one may contrast it with other third-party situations, such as the decision of Mr. Justice Popplewell in Seamaster Shipping in 2018, in which he held that a bank which became the lawful holder of a bill of lading became a party to the arbitration clause pursuant to Section 2 of the Carriage of Goods by Sea Act 1992, and that the arbitration agreement could not be split into rights and obligations, and therefore the proceedings were brought against it. One of the questions now is whether that decision will continue to be regarded as correct in light of the Supreme Court decision in Aspen Underwriting. Of course, in Seamaster Shipping, Mr. Justice Popplewell was considering specifically Sections 2 and 3 of the Carriage of Goods by Sea Act 1992, rather than an equitable assignment. It does remain to be seen whether that is the correct position. Well, thank you very much for listening, and I'm happy to take any questions.
Thank you very much indeed, Yvonne. And we've allocated about 10 minutes for questions at this point before I ask Miriam Goldby to continue. There are quite a number of issues, I think, which arise in relation to, to jurisdiction in ship finance projects. And one of them, which perhaps I could raise at this point, is the significance of arbitration. As to what we've been talking about so far is largely confined to court proceedings, where a bank is or is not entitled to launch proceedings in a particular jurisdiction and then have proceedings which have been initiated by a borrower stayed so that the bank can continue in its own preferred jurisdiction. But one does also come across arbitration possibilities, not least in ISDA-type financial instruments, where one party is given the opportunity either to sue in court or to initiate arbitration proceedings. And this is not perhaps so common in loan agreements or some financing agreements, but it does have perhaps certain advantages, not least under the New York Convention, the possibility of being able to enforce an arbitration award in any of 150 countries which are party to the convention. I wonder if you'd like to comment on that, Yvonne, and as to whether lenders should probably more commonly consider in ship financing agreements the possibility of using arbitration as a means of enforcement.
Well, of course, one of the issues that has arisen as a result of our withdrawal from the European Union is if we don't have an agreement, for example, on the 2007 Lugano Convention, whether we would then we would fall back on our common law position in relation to jurisdiction clauses, and in that event whether we might do better to have more arbitration clauses in contracts. I think from the bank's point of view that will depend really particularly on how helpful they would see arbitration proceedings in the places where the borrower's assets are located, and how easily they would be able to enforce that arbitration award, any arbitration award which they've obtained in those other countries where assets are located. I think it's fair to say that as far as arbitration is concerned, if we do have the 2007 Lugano Convention, we don't have any adequate interface between arbitration and the 2007 Lugano Convention. We still couldn't grant anti-suit injunctions to restrain proceedings in another Lugano contracting state where there's a London arbitration clause. But if we don't have the 2007 Lugano Convention at all, then we might be able to start granting anti-suit injunctions again in order to restrain a party from pursuing proceedings in another state in breach of a London arbitration clause. So rather than
I know there are, of course, some jurisdictions which do not accept asymmetrical arbitration agreements or an agreement to arbitrate where only one party is given the opportunity to launch an arbitration as valid. These include, as I understand it, Russia, Turkey, Poland, China. So one may have to select one's jurisdiction quite carefully. I have another question here, if I could read it. Do you think, Yvonne, that if the English courts would follow the Gasser reasoning after Brexit, provided the UK has ratified and acceded to the Lugano Convention in its own right, and provided the UK has become a contracting state to the Hague CCA 2005 post-Brexit, do you think if the English courts interpret the convention as to cover asymmetrical jurisdiction agreements as well? I wonder if that question is clear. Perhaps you could comment on it, please.
I think probably there are two parts to that question. First of all, if we have the 2007 Lugano Convention, as I've understood it, the question was, would we still apply Gasser?
Yes.
Absolutely. Absolutely. And the irony is that although we didn't have to, the Master Melt decision, the decision of Mr. Justice Waxman in the recent decision in Master Melt quite clearly says that we would be bound by Gasser and MESAT. So I think we're definitely bound by Gasser. I think that's right. I don't think that you can start interpreting the 2007 Lugano Convention in light of reforms which were made to a subsequent regulation. And as far as the Hague Convention is concerned, the Hague Convention is not subject to Gasser, and therefore I think that if, for example, we were the English court chosen in an exclusive English jurisdiction clause, and it is probable that we would decide that an asymmetric jurisdiction clause was exclusive, if we follow the dicta of Mr. Justice Cranston and Mr. Justice Jacob in Liquimar and Etihad, that we could take jurisdiction on an asymmetric jurisdiction clause and give a judgment. And that
I'm sorry to interrupt you there. Could we ask you perhaps to speculate a little, this is perhaps more a political question than a legal question, as to whether the EU 27 and it seems Denmark separately are likely to agree to the accession of the United Kingdom to the Lugano Convention. And if not, why not? What would their objections to?
Okay, their objections at present are that, unlike all the other contracting states, we do not wish to be part of the European single market. And therefore, we are in a different category from all the other contracting states. And at the moment, as I understand it, the European Union is saying, well, look, we're not prepared to negotiate a standalone convention on jurisdiction. We want to look at the position as a whole, and you, the United Kingdom, cannot just pick off bits in relation to an agreement with us. They want to try and reach a package on everything simultaneously, or at least what they can, and not just little bits at a time.
So it's not clearly, as the Americans might say, a slam dunk.
It is not.
Before we move on to our next presentation, thank you very much indeed to Yvonne for her presentation and answering these questions. Perhaps I could clarify that the presentation materials will be available to the participants, and also that a recording is being made of the proceedings today, and I hope that that will also be it'll be possible to make that available. So perhaps I can move on now to our next presenters, Miriam Goldby and Panagiotis Vavougyios, who are going to present together on the subject of innovation and finance overcoming the challenges. Panagiotis is an associate with the finance group of Stevenson Harwood, the international law firm, focusing on asset finance and specializing in shipping finance. He's currently on secondment at BNP Paribas in Paris. He is an alumnus of Queen Mary University of London, having master's degrees in commercial and corporate law and international shipping. Miriam Goldby is reader in shipping, insurance and commercial law at the Centre for Commercial Law Studies at Queen Mary University of London, excuse me, and director of the Centre's Insurance, Shipping and Aviation Law Institute and of the LLM program in international shipping law. She's a member of the CMI Standing Committee on Carriage of Goods and vice chair of the ICC's UK Commercial Law and Practice Committee. She's also the author of a number of important works on shipping law and practice. So if I may, I'll hand over now to Miriam, who I think is going to speak first, and she in turn will hand over to Panagiotis, and we will take some questions after the presentations, and if you could keep the questions coming, please, on the chat function. Thank you.
Thank you very much, Ian. I put my video on to say hello to everyone, but as Yvonne did, I will stop my video during the presentation when I start sharing my screen. This is just to improve connectivity. So I'm going to share my screen now. Yeah, that should have done it. And I will turn my video off. Okay, so thank you very much for your attendance. Through this presentation, Panagiotis and I will be attempting to give you some insight into innovation in ship finance. We'll also look at what has prompted these innovations and what are the contextual factors that are likely to affect the availability of ship finance going forward. Our presentation will be in two parts. We will start by giving some context. Apologies, I'm just trying to go to the next slide. There it is. We will start by giving some context. We will be looking at relevant trends in the shipping industry. These trends are emerging as a result of business needs and regulatory requirements. We will also be giving a brief overview of the impact of restrictive measures adopted in response to COVID-19. Then we will move on to the second part. This will consist of a forward-looking discussion of developments and innovations in ship finance, within this context of emerging trends. So the contextual factors shown in this slide are the ones we consider to be the most relevant to ship finance going forward. And there are two categories of trends. First of all, there has been the realization that if the shipping sector were a country, it would rank 6th in emissions in the world. Now, this has prompted the adoption of measures to regulate emissions, most notably IMO 2020, which you've all heard of, in response to which ship owners are having to install scrubbers at considerable expense, or switch to much more costly, very low sulfur fuels. Essentially, these are economic decisions, whether to install a scrubber, whether to switch to cleaner fuel. And these decisions are of interest to financiers, those funding or deciding whether to fund the transition. Ironically, as you can see from the graph on this slide, one of the effects of COVID-19 was to put a pressure on the price of very low sulfur fuels, which are also used by the airline industry and which has not been flying essentially for a number of months. So the price of very low sulfur fuels has gone down, meaning that the differential between it and high sulfur fuel oil has decreased. And this has reduced the costs of those ship owners who opted to burn cleaner fuel rather than install scrubbers. Now, more long-term, the IMO is implementing a strategy aimed at decarbonizing the industry by reducing shipping's total greenhouse gas emissions by at least 50% by 2050. A final item in this category of trends comes from the EU. The EU has adopted in 2015 the Monitoring, Reporting and Verification Regulation. As some of you will know, there is currently a proposal going through the legislative stages aimed at amending the MRV regulation in order to take into account the new IMO global data collection system, which was launched last year. Now, as we shall see later on, these are significant legal developments for ship finance. The other big shift we are seeing within the industry is an acceleration of technology adoption. Technology adoption includes both technology designed to increase the ability of vessels to operate without crews on board, and technology designed to transform logistics processes by, among other things, dispensing with paper documents. Which are still in ubiquitous use in seaborne trade. So if one looks to the future, both of these contextual factors, that is environmental protection measures and technology adoption, are likely to result in an industry that looks rather different from today. And financiers are likely to be interested in the extent to which the vessels they are financing and the business activities of their debtors are future-proofed and able to withstand the implementation of these changes. I'm going to hand over to Panagiotis now, who will give you some insight into the impact of COVID-19 on ship finance, and also the pressures which may in future give rise to the need to innovate in ship finance. So Panagiotis, over to you.
Thank you, Miriam. I hope you can all hear me well. Hello everyone, and thank you very much for joining us in this webinar. Initially, when we started structuring this, we weren't sure whether we should be including in our presentation any topics related to COVID-19, but its impact in the shipping market and the market's response seem now to be very much relevant to this presentation, which, as Miriam mentioned, aims to cover the innovative solutions that the shipping industry has adopted in order to navigate through various challenges over the past years. For the purposes of this discussion, we shall focus on the areas mostly affected by COVID, the current difficulties imposed on ports, shipyards and crews, and the market's response to these recent developments. Let's start by considering the sectors of the industry that have been mostly affected. There has been extensive media coverage regarding the impact of COVID in the cruise market. In fact, since the outbreak of the coronavirus, many trips have been cancelled, and customers continue to claim refunds for these trips. In addition, the vessels that do not travel during this time, they need to be brought in a layup status, and it of course adds extra costs to the owning companies in order for them to maintain them in good condition. What we also should keep in mind regarding this industry is that this is a huge market with millions of passengers that choose to go on cruise each year, and at the same time, these vessels are worth hundreds of millions of dollars. This industry is also particularly important for Europe, as many cruise vessels are actually built here, and many major financiers, including European leading banks, have invested heavily in this sector. The cancellation of the cruise trips and the cash flow problems that the cruise companies currently face have significantly affected their repayments under their own financing agreements. As you know, failing to make a repayment under a finance agreement when this is due, it may lead to a default, which would typically result in acceleration of the loan. You can now imagine the scale and the impact of this situation when most, if not actually all cruise lines found difficulties in repaying their own loans. This was no doubt an unprecedented situation that called for an immediate response from financiers and borrowers. They had to find innovative solutions in order to address all these challenges. In fact, indeed, over the past months, we have seen cruise lines, financiers, and I might say to some extent governments working together in order to create the appropriate framework which would allow postponement of payments and in some cases restructuring of financing arrangements. Now the situation is similarly difficult for bulk carriers and container ships where rates actually are depressed. We have included in the following slides extracts from the Baltic Dry Index and China's Containerized Freight Index as examples to illustrate how COVID outbreak has actually affected the rates in these sectors. Now for your reference, thank you, Miriam. Let's go to the Baltic Dry one. For your reference, the Baltic Dry Index is a shipping and trade index which measures changes in the cost of transporting various raw materials such as coal and steel. Now you will note in this graph that there is a tremendous drop since the start of December 2019. And then, as you can see, in fact, the last time the Baltic Dry Index was below 500 points was in February 2016, which was arguably one of the toughest years for the industry. In the next slide, we have included an extract from the CCFI, which, for your information, basically tracks spot and contractual freight rates from Chinese container ports for many shipping routes, and this is based on data from various international carriers. You will see that the index saw an overall increase in December 2019, which was then followed by a significant decline in the first weeks of 2020. However, there are some optimistic voices within these markets that note that the impact will be bearable and that there is currently a built-up demand, which could potentially help to avoid a nightmarish scenario. Now, going back to our previous slide, another apparent impact of the coronavirus is the significant delays and the fall in the activity at the ports worldwide. This is the result of various factors, such as the production suspension, strict traffic restrictions, and additional custom checks that have been reported in some ports. There are, of course, less people working on site. Similar issues have been identified in shipyards where, due to the measures imposed, deliveries of vessels have been delayed. There are actually even cases where the new buildings are ready, but the own companies cannot fly their crew on site, and therefore they are unable to get control over that vessel. As you can imagine, this can affect the delivery and the construction financing, as the economics and the timeline of these projects might change significantly. To consider a simple scenario whereby a bank has obtained an internal approval to make available a facility at a certain period. Now, the way this end date is actually calculated is through a complex process where various factors are taken under consideration. Imagine now that due to the delays at the shipyard, this availability period has now expired. This could potentially cause issues for the borrowers and the yards who were expecting these funds until a certain date. And of course, this adds an extra burden to the financiers who now have to consider whether an extension under the same terms is possible, and of course to their interest. It has also been difficult for shipping companies to carry out crew rotations since various countries, including major maritime nations, have now imposed certain restrictions or have prohibited crew changes altogether. Travel restrictions are preventing actually people who work on ships from disembarking and their replacements from boarding. As you can imagine, this has severe implications to the crew who might be called to stay on board for several months beyond their initial contracts. We have noticed over the past weeks, international shipping organizations, trade unions, and ship owners urging countries to recognize merchant crews as essential workers and allow them to travel and carry out crew changes. But what about closings with regards to shipping finance projects? To those of you who might not be very familiar with the various steps of a shipping transaction, allow me to note that the closing meeting is actually one of the most important stages of this project. During a closing, it is customary for representatives for the parties to physically gather and conclude the project by signing the relevant documents, releasing instructions for funds to exchange hands, and registering the relevant securities, including the mortgages over the vessels. During this time of the pandemic, this process is not forthcoming, and the industry had to adapt quickly. Now, keeping in mind that the shipping market is rather old school and not very fast moving, implementing virtual closings and getting the various players not only to issue, but to accept electronically signed documents, it hasn't been an easy exercise. And we must also keep in mind that hard copies remain to a great extent an aspect of the maritime industry, and perhaps this recent development in that field could potentially accelerate the process towards a paperless transactional maritime sector. Of course, virtual closings and electronic signing have various considerations, and especially when one takes note as to the relevant laws and ship registry requirement. So we should always seek for the appropriate legal advice. Now, although the overall impact on the industry, it really remains unknown, I believe it's certain that financiers, borrowers, charterers, yards, and of course their respective legal counsels should work together to address all these unprecedented challenges and find innovative solutions in order for financing to continue uninterrupted. And in fact, we have seen this happening already, and this is actually a very positive sign during this crisis. Right, now moving on to our second part of this presentation. We will be covering the availability of finance and alternative sources of financing in the shipping industry. As briefly mentioned earlier, it has been apparent that due to the implications of COVID, there is going to be an increase in demand for financing, and perhaps alternative means will also play a vital role in the near future. But let's take a step back and consider why finance is so important, and perhaps explain in simple terms what a shipping finance project actually is. Considering the value of the vessels and the high cost of operation of the various companies, one can understand why financing has been in the center of this industry for so many years. If used properly, financing can be a powerful tool, and the shipping companies can actually use it to meet their liquidity requirements, operate their companies and their vessels, and of course continue investing in the industry. At the same time, financing arrangements can be very profitable for the financiers, as they can expect high fees and steady cash flow of course, when times are good and their clients performing under these loans. Now, without considering all the parties involved in a ship project, a simple structure would involve a lender providing funding to a borrower for the purchase of a vessel. Now, this can be either a new build, which is under construction, or actually a vessel that already exists and which is being purchased by the borrower as a second-hand vessel. The lender may also provide funding to the borrower for refinance of the existing indebtedness in respect of an already existing vessel. In the years following the global financial crisis, we saw several developments, and there has been a considerable change in the way vessels are financed. In fact, it has been estimated that in 2016, the loan volume for syndicated shipping lending was around $50 billion, which is significantly less than the $120 billion value estimated for 2007. Initially, it was common for traditional shipping banks to play a key role in the industry, and it was for them to cover most of the financing requirements. This, however, is no longer the case, and we have seen many of these banks to have now exited the market or gradually continue to sell their shipping portfolios or allowing existing loans to amortize, but without taking on new businesses. It has now transpired that the global financial crisis had a tremendous impact in the maritime industry, but there are also other reasons that formed this landscape. For example, there are now strict capital, liquidity, and risk management requirements that are imposed to European banks, which had led them to apply, let's say, more conservative strategy when lending to shipping companies. It is now very common, for example, for these institutions to lend money to strong existing clients and to large companies which are actually in an exceptionally sound financial condition. This in turn has left mainly small to medium-sized ship owners without substantial access to financing. This gap created the need for new players who had access to cash and were of course willing to invest to enter the market. In addition, there was an immediate need for innovative solutions to be invented in order to meet the ongoing needs, and I might say urgent needs, of the shipping companies. We shall now briefly mention some of the key players of such alternative means of financing, and Miriam will later on expand to some of these. You might have heard about the export credit agencies. Now, an ECA is usually a government entity, but can also be a publicly or privately owned company acting on behalf of the relevant government. The involvement of ECAs is often welcomed by other commercial lenders, as it may allow them to mitigate their capital allocation requirements. ECA-supported financing has been, for the past years, let's say, stable source of funding for the shipping industry. An ECA can either provide credit to ship owners for the purchase of or the part acquisition of a vessel from a yard, and we should know that this yard is usually located in the jurisdiction of that ECA. An ECA can also guarantee or insure the commercial lenders. In addition, we have seen the Chinese banks and leasing companies to be involved in the shipping industry by investing in finance projects, while at the same time they support their domestic shipbuilding industry. Another distinct means of financing that entered the market following the financial crisis and provided significant support was through private equity. And I might say that since then, it has got a prominent role in this new financing landscape. Right, that's all from me, and thank you very much for your attention. Miriam will now provide us with some useful insights as to this alternative means of financing in order for us to better understand the impact of these structures.
Thank you very much, Panagiotis. Panagiotis has basically given us the reasons why alternatives to traditional finance have become necessary in the maritime sector. My job now is to give you an overview of alternative finance and to attempt to look forward at what the future might hold in this space. Alternative finance refers not just to the way financial deals are structured, but also to who the financing party is. Alternative sources of finance really started to become necessary after the 2008/9 financial crisis, as Panagiotis has just explained. This is when the availability of bank credit began to reduce. Alternative finance providers were able to step in because they are subject to fewer regulatory restrictions than banks and can take higher risks. But of course, they also seek a higher yield, so finance is provided at a higher cost. As you can see from this news report from 2013, some early examples involved private equity funds entering into joint ventures with ship owners. The investors in the fund included not just institutional investors like public pensions and insurers, but also high net worth individuals, that is, retail investors. A more recent example is a joint venture between an asset manager and fintech provider. This is an interesting development, as fintech permits capital to be sourced from a wider variety of investors, again, potentially opening up the retail investment space as a source of finance to the shipping industry. The involvement of retail investors is significant because several studies have shown that retail investors, particularly millennials, take into account environmental, social, and governance factors when taking investment decisions. So I have put on this slide here an extract from the most recent Legg Mason survey, according to which, as you can see here on the right, 49% of investors surveyed reported that they choose funds to invest in according to ESG considerations. Interestingly, it also found that if more data were available about ESG credentials, more funding would be available. Now, this is very important to the shipping industry, as it is moving towards integrating environmental considerations into the development of new vessels and business processes. Now, the Natixis survey, again, this is another survey of investors, essentially found that investment with ESG credentials are attractive because they help, as you can see in this rather tiny writing down here, because they help align investors' assets with their personal values. It also found, and this is the bigger writing at the bottom, that nearly 2/3 of institutional investors believe that ESG investing will become an industry standard within the next 5 years. And bear in mind, these are institutional investors, so the interest goes beyond the retail market. Another reason why ESG investments are attractive is because they consistently outperform the wider market, as reported in this Financial Times article. I do not find this correlation to be surprising at all. Indeed, the scrutiny that goes into setting up funds with ESG credentials goes further than it would for those without. This is because a large amount of data needs to be examined to establish compliance with ESG requirements. So those managing ESG funds are likely to have more granular understanding of potential investments. In other words, they will choose solid options because they know a lot about the thing they are investing in. Now, you will all be aware that ESG requirements extend further than just environmental factors, such as low emissions and the protection of the marine environment. They also cover factors such as crew welfare, health and safety standards, sustainable procurement practices, corporate governance, etc., etc. So there's quite a lot to ESG. However, the attainment of certain environmental standards is a key part of demonstrating ESG credentials. Not only that, but as we have already seen, demonstrating compliance with certain environmental standards is also necessary in order to comply with IMO requirements. So it can be said that the adoption of environmentally friendly practices is now a key part of future-proofing and ensuring sustainable growth within the shipping industry. Now, this brings us to the Poseidon Principles. These principles, adopted about this time last year, they provide a framework for integrating climate considerations into ship financing decisions in order to promote international shipping's decarbonisation. Essentially, the principles provide a methodology for financiers to scrutinise and gather data on their clients' carbon intensity. So on the carbon intensity of the assets that they are going to invest in. This data is then aggregated and published so that the financier's lending decisions can be assessed on the basis of how well they align with established decarbonisation strategies, such as the ones of the IMO and the EU, which I talked about earlier. So far, the Poseidon Principles have been adopted exclusively by banks. However, our feeling, we consider that they could potentially provide a framework also for alternative finance to act in response to increasing demand for ESG investments. As you can see, and this is my final slide, so we will be done soon, the first two of the four principles involve the assessment of reliable data derived from unbiased sources, including classification societies and the IMO. The third principle involves the creation of an obligation on the debtor to disclose the necessary information, the debtor being the ship owner in the case of ship finance. And the final principle relates to transparency. Anyone who knows anything about ship owning will immediately recognize that these principles are likely to raise concerns among vessel owners. In particular, concerns in relation to the costs of collating data and submitting it to the lender. Now, the covenant clause mentioned in the third principle, this places the cost of collating data and submitting data on the ship owner. So that's the first concern, the cost. And secondly, the possibility of public exposure and reputational damage as a result of the publication of the alignment scores. So essentially, this is an obligation on the lender to publish their alignment with decarbonisation strategies, but it might end up indirectly affecting the reputation of the ship owner. Now, the covenant mentioned in Principle 3 deals with these concerns. Under it, vessel owners must provide to the bank, and I quote, all ship fuel oil consumption data required to be collected and reported in accordance with Regulation 22A of Annex 6 of the 1997 Protocol to the Maritime Convention, and any statement of compliance. That is, this is the data that they are providing anyway to the IMO. And it also, the covenant also provides no lender shall publicly disclose such information with the identity of the vessel without the prior written consent of the owner. That is, the intention is to require from the debtor the same data already required to be submitted under IMO regulations, and to publish it only in aggregated and anonymized form. Because the purpose of publication is to give a picture of the lender's overall portfolio rather than its individual assets, that is, individual vessels. Now, just a quick note before I end on reporting costs. It's really interesting to read more widely about ESG because this is a challenge facing ESG funds generally. And it's a challenge because there is no universal standard for data reporting, ESG data, that is. And methodologies for assessment of ESG data and ESG credentials vary widely. They vary widely among sectors, and they vary widely also within sectors. Now, it's to be hoped that standardization will be achieved. There is work being done towards this, and that technological tools will eventually automate much of the reporting process. What this will do is it will reduce costs, it will make more data available, and it will increase the availability of finance, which is essentially a really important objective for the shipping industry. So my time is up, and I will end our presentation here, and do let us know if you have any questions.
Thank you very much indeed, Miriam and Panagiotis. This is a very interesting presentation regarding the current state of the ship finance industry, because we're in a state of dramatic flux, not only in the short term because of the impact of COVID-19, but also in the longer term because of the IMO requirements to meet their targets in 2050. If I could just ask a question, first of all, about the shorter term, and particularly the cruise industry, which is an industry in which I spent some time working. The current shipbuilding portfolio in Europe is likely to be that there are some 15 or thereabouts ships under construction, primarily in European shipyards, including Fincantieri, Meyer Werft, and Chantiers de l'Atlantique being the world's leading providers of cruise ships. And banks are going to be faced with a double whammy, as it were, in that the construction times for these ships are going to be prolonged, which means that construction finance is going to be more expensive because of the lockdown and the fact that these shipyards were not in operation for some period, and the fact that the market for cruises, at least in the short term, has collapsed, with the cruise companies having to take emergency measures in order to raise funds from, for example, sovereign wealth funds in the case of Carnival and NCL, and I think also RCCL. I wonder, Panagiotis, without giving away any secrets or confidential information, you can give us some indication as to how the players in these markets are actually coping with this very, very dramatic and very sudden situation.
Right, thank you. Actually, it's a very interesting question, and obviously I can't get into much details, but what I can say is that there is actually a consensus for all these parties to work together and find viable solutions, because we have to keep in mind that it is to the lenders' interest for these companies to continue being in a sound financial position, because they have a huge exposure. And there is also some recent reports that the impact in the cruise industry might not be as nightmarish as one initially thought. So we have seen some reports that perhaps from next year things will get better. And obviously they have to work around these predictions and be sure that they can work around plans to find solutions that will be proper for all of them. And as you mentioned, the shipyards, they have a key role to play in this situation, and this is where the governments, they come in and contribute, and they sit together with all the other parties and try to find solutions which will be workable for all of them. Yes,
thank you. Looking at the longer perspective and the IMO requirements to reduce carbon emissions by 2050, obviously this is a longer horizon, but listening to shipping economists like Dr. Martin Stopford, for example, it's still by no means clear how this is going to be achieved. It seems at first sight to be a long way away, 30 years from now, but of course investments are going to have to be made in the next few years for ships which are going to have a life of possibly 25 years, and major investment decisions are going to have to be made on certain assumptions as to how this is going to be achieved. One of the solutions suggested by Mr. Stopford was that we're going to develop towards a world of much more regional economic organizations and economic markets, away from the trend towards globalization, which we've seen in the last 20, 30, or perhaps more years, so that it is actually those changes in trade patterns which will actually reduce the shipping miles which are required in order to service these more localized markets. Do you see that as being a factor, and does that mean that we're in fact going to need fewer ships?
Ian, is it a question for me or Panagiotis?
Well, I invite both of you to address it, perhaps.
Well, I can't pretend to have any ability to make economic predictions. Like you, or like Professor Stopford, I think that we are likely to see the industry change in many ways. Regionalization may be one way, but I really do have a lot of faith in technological advancement. And I think that solutions, creative solutions, will be found, because necessity is the mother of invention. And we have got to a point where we cannot sit on our hands anymore. Something needs to be done. So I think that there's a lot of ingenuity, a lot of research going on. And I think that eventually the shipping industry will realize the benefits of jumping on the bandwagon and really scrutinizing all possible solutions and opportunities going forward.
Thank you. It's quite an optimistic message. Panagiotis, would you like to comment on that at all?
Well, I agree with Miriam. I think it's a positive sign that we have seen these Poseidon principles to be very much welcomed by major financiers, and I can say that we have seen also owners to actually see this positively. But as Miriam mentioned, there are some issues that need to be addressed. But I think once they feel comfortable with the actual context, then they can see that positively. And I agree that we have to have faith in the technological advancements and consider all these impact to the environment. So I think we are maybe slowly, but we are going towards a more environmental friendly framework.
And in the past, financiers have not necessarily been noted for their altruism. Is their approach to the Poseidon principles and assisting in the protection of the environment, is this a new trend among financiers, or do they see this as a matter of self-interest?
Well, I guess it's also a matter of a business perspective. When you see some major, let's say, competitors taking the opportunity to implement this kind of framework in their financings, then it's also perhaps good for the other banks to follow and join them. And I think it's a combination of things. And obviously, being environmentally friendly during these times is of paramount importance, and only can benefit these financiers and the owners that accept to join this framework.
Thank you.
Yes,
Miriam,
I'd like to add something to that, Ian.
Yes, please do.
I think essentially complying with the Poseidon principles is perhaps an extension of what financiers already did, which is find out as much as they can about the people they are lending to and the businesses they are lending to. And essentially the way I see the Poseidon principles is that they are a window for obtaining further data that will assist in understanding the health and the long-term potential of the business you are investing in.
Thank you. You drew attention to the huge drop in the differential between heavy fuel oil and low sulfur fuels, which has had an impact on plans of some shipping companies to install scrubbers. Do you think we've now seen the end of scrubbers, or what do you see as the future in this area?
Well, Panagiotis is probably better placed to answer this, but from my perspective, I I think that the price of very low sulfur fuel is going to go up again very quickly as soon as planes start flying again. And it's really for every ship owner to make the best economic decision, or what they think is the best economic decision in the medium to longer term. Because so I don't know the science about how long scrubbers last, but they are very expensive, and you need to make the judgment call as to whether during their lifetime they are going to result in sufficient savings to make them worthwhile. And obviously with the price of oil being so volatile, it's very hard to make that assessment.
Thank you very much. Before we bring our proceedings to a close, I have one final question for Yvonne, if Yvonne could help us with this. One of our audience has asked, in relation to Aspen, the recovery claim was made against a single EU lender, a recipient of the insurance proceeds. What would have been the position in the case of a syndicated loan, where there were several lenders or recipients of the insurance proceeds, some of whom were not EU member states? Could the outcome have been different if the insurers had been obliged to sue a number of banks, some of whom might not have been subject to parties to the Lugano Convention? Would you be able to help us with that?
Okay, so we've got syndicated loans with a number of different lenders. All those lenders who are in an state, or I think a Lugano contracting state, would be bound by Aspen, and it would be necessary to sue them where they are domiciled. And that is another horrible consequence of Aspen, because we then have even further fragmented litigation, that you can't join them all together as you would like to, using, for example, Article 8, because of the Article 14 provision. As far as the lenders are concerned who are non-EU member states or Lugano contracting state domiciled or residents, then we would apply our common law rules, and at common law I think we would apply exactly what the Supreme Court has held in Aspen, because it is in fact a common law principle in Aspen. What we're looking at is English law on whether the bank is successor to the English jurisdiction agreement in the insurance contract. And therefore, I think the Aspen decision would also apply to a bank or lender which is not in an EU member state. Whether we would be prepared to join them all together under our common law rules is a more complex question. As regards the European domiciled defendants, they're protected by Article 14 of the Recast Regulation. As regards those which are not protected by those rules, then one might be able to join them together.
Thank you very much indeed, Yvonne.
They're not going to be bound by the English jurisdiction agreement where the insurer sues the lender.
Thank you very much indeed, Yvonne. And that brings us to the end of our webinar. I think, if anything, this webinar has served to demonstrate that shipping and shipping law is never dull. And I'd like to thank our speakers for their very interesting presentations, and you, the audience, for your questions and for taking part in this webinar. Thank you very much indeed, and I'm sure that our speakers will be able to answer any other questions you might like to field for them. But that is the end of the proceedings for today, and you might like to show your appreciation by pressing the reactions button on the at the bottom of your screen. Thank you very much indeed.